You're charged with unlawful possession of a firearm by a felon. But all of the priors, this is showing that you are an habitual felon, which means you're looking at a minimum of 25 years in prison to life. You were habitual felons.
Hold on a second, did you catch that? The judge just mentioned habitual felon status. That's a legal game changer. In many jurisdictions, habitual offender enhancements can dramatically increase prison exposure. We're not talking about months here, we're talking decades. When the words
Convictions ago, since 2018. So here we are. Yes. Announcement.
We can get about 4 weeks from now, so I can get something straight down on this. I don't, yeah.
It's not.
Yeah. We need more time to just help work out, get it resolved.
Okay, I'll reset it. 4 weeks, get it resetting. Have a seat right over here, please. Probation.
Not on the highlighted next one, please.
Let's put him in the penalty box. Thank you. Yeah, drugs in this arrest. You've tested positive for tetrahydrocannabinol marijuana. That is, it's a crime to imbibe and possess marijuana. It's in your system. It's going to affect your bond. You have a $50,000 bond and a GPS device right now. Is that right?
Yes.
Is that what I just?
Yes.
Hold on a second, did you catch that? The judge just mentioned habitual felon status. That's a legal game changer. In many jurisdictions, habitual offender enhancements can dramatically increase prison exposure. We're not talking about months here, we're talking decades. When the words 25 years to life enter the conversation, what started as a routine court appearance is suddenly turning into a bond hearing disaster. One positive drug test can trigger a chain reaction, especially when a defendant is already under court supervision. Watch how quickly the judge's tone shifts from administrative to enforcement mode.
All right. Yeah, he's got a GPS device, right?
Right, yeah.
And, all right. Well, you've tested positive. It's a $50,000 bond. It is revoked. You are now $100,000. Plus, you must have a drug patch at all times.
Hold on a second, did you catch that? The judge just mentioned habitual felon status. That's a legal game changer. In many jurisdictions, habitual offender enhancements can dramatically increase prison exposure. We're not talking about months here, we're talking decades. When the words 25 years to life enter the conversation, what started as a routine court appearance is suddenly turning into a bond hearing disaster. One positive drug test can trigger a chain reaction, especially when a defendant is already under court supervision. Watch how quickly the judge's tone shifts from administrative to enforcement mode. Things are about to escalate fast. What started as a routine court appearance is suddenly turning into a bond hearing disaster. One positive drug test can trigger a chain reaction, especially when a defendant is already under court supervision. Watch how quickly the judge's tone shifts from administrative to enforcement mode. Notice the judge's repeated emphasis on science. This is one of those courtroom moments where personal explanations collide with objective evidence. The defendant insists he hasn't used marijuana, but the court is focusing on the test result itself. Whether you agree or disagree, the judge is making it crystal clear. In this courtroom, laboratory results carry more weight than verbal assurances.
As a condition of your bond.
Your Honor, I know he says not THC. He says he hasn't used any products, but he does have a medical marijuana card. And he hasn't used any, but he has a card that allows him to do that medically. I mean, I know the court has a different feeling on that.
I do.
I understand that, but I'm just saying that this is something that there's a medical.
I'm sorry. Your bonds are revoked, period. It's the way it is. Drugs on my watch are not allowed.
I haven't smoked marijuana.
I don't care. They all say that. It's in your system, sir. Everybody says that. And wouldn't you, don't you think if somebody would just say, I've never done this, can I go home now? It would be pretty simple, but that's not the way it works. We test. If it's in your system, shame on you. And I didn't grant it. I don't allow it. And that's the way it is. Y'all got to figure that out. His bond is revoked. And is it set? We said this for trial, right?
No, not yet, Your Honor. No.
Figure out what we're going to do.
We said,
We had a reset for 4 weeks for an judge.
Okay,
Quicker than that.
you're taken into custody, period. That's the way it is. Robert Chason, come on in.
Excuse me, Your Honor. Can I recess? Your Honor.
I'm sorry, sir, everybody says that, but the tests are scientific and I rely on the scientific tests.
Yes, sir. I have a marijuana card, but I still haven't smoked. I don't smoke.
Sir, you've tested positive for marijuana. I'm gonna rely on the science.
Well, back on here.
I'm gonna rely on science, sorry. But your lawyer's gonna talk to you. There's some things we might be able to do.
Yeah.
You were charged in this indictment with the second-degree felony of assault on a peace officer. And that carries with it no less than no more than 20 years confinement in prison and a fine up to.
Hold on a second, did you catch that? The judge just mentioned habitual felon status. That's a legal game changer. In many jurisdictions, habitual offender enhancements can dramatically increase prison exposure. We're not talking about months here, we're talking decades. When the words 25 years to life enter the conversation, what started as a routine court appearance is suddenly turning into a bond hearing disaster. One positive drug test can trigger a chain reaction, especially when a defendant is already under court supervision. Watch how quickly the judge's tone shifts from administrative to enforcement mode. Things are about to escalate fast. What started as a routine court appearance is suddenly turning into a bond hearing disaster. One positive drug test can trigger a chain reaction, especially when a defendant is already under court supervision. Watch how quickly the judge's tone shifts from administrative to enforcement mode. Notice the judge's repeated emphasis on science. This is one of those courtroom moments where personal explanations collide with objective evidence. The defendant insists he hasn't used marijuana, but the court is focusing on the test result itself. Whether you agree or disagree, the judge is making it crystal clear. In this courtroom, laboratory results carry more weight than verbal assurances. Just when it seems the marijuana issue is the biggest problem, another bombshell drops. Remember, bond violations can create immediate consequences, but felony assault charges can create life-altering ones. The stakes are about to jump from bond conditions to potential years behind bars. Let's put these numbers into perspective. The defendant is now facing multiple felony allegations, and the judge is discussing the possibility of separate trials. That's significant because each charge carries its own potential penalties. The judge's final message of the day. What looked like one legal battle is starting to resemble several battles happening at the same time. Whether viewers see this as strict accountability or an aggressive approach to pretrial supervision, one thing is undeniable: every decision made before trial can have consequences long before a jury ever hears the case. And there it is, the judge's final message enforcing the rules, or did this hearing take an unexpectedly harsh turn? Warning issued. Let us know in the comments. Whether viewers see this as strict accountability or an aggressive approach to pretrial supervision, one thing is undeniable: every decision made before trial can have consequences long before a jury ever hears the case. What do you think? Is the judge simply enforcing the rules, or did this hearing take an unexpectedly harsh turn? Let us know in the comments.
$10,000 can be assessed. Do you understand what you are facing here, sir?
Yes, sir.
All right. This is an announcement.
Your Honor, we've gone over this case, talked to my client.
How's that work? This is an announcement.
Your Honor, we've gone over this case, talked to my client.
How's that working?
Yeah, that's working fine.
Okay.
But my client is not does not want to take the offer, so
Trial.
there for trial.
It's set for trial, and just have a seat right over there before you leave. Get a resetting program.
You get right there.
And then, hey, hold on.
What it is?
There was two cases.
Yes, 2 cases.
Yes.
Mr. Chason, we're not through. Sorry. Oh, yeah. You had another charge here in 25 CR 1846. You're charged with harassment of a public servant, which carries with it, it's a third-degree felony, so that is no less than 2 nor more than 10 years to be fined in prison, and a fine up to $10,000. What we will do is, let me see the previous file, please. Let's start that you don't. That's a player. It's the same event.
Yes, Your Honor, part of the same incident.
I'm sorry, did you say, yes, no? Those are the words, and then dictionary. What state want to do on this? Try them both at the same time? Or,
I don't know what I want to do on that at
Okay.
this stage, Judge.
okay.
Likely I will try the assault first.
Well, it's second degree felony. So you were looking up to 30 years in prison for both of these. Do you understand?
Yes, sir.
Okay, you got a resetting, have a seat over there.
I don't think he's on.
Not yet. Yeah, judge called back for it.
Designing Matherson.
That's a defendant. It's not going to be available.
Does he have fires?
No.
It's nothing.
No.
It's. And
Shocker.
Mr. Chason, you are positive for marijuana as well.
Yes, sir.
I just recently quit 2 weeks ago. I should be clean. I did.
Your bond is $20,000 on each case, 2 cases, they're doubled to $40,000 on each case. The
Yes,
bond to revoke, they're doubled, plus you must have a drug patch at all times. And next time, if you can post this, it'll double after that when I test for you. But you don't come to court
Yeah.
on drugs, period, in the ballgame. I'll give you, you get a copy of this.
Yeah, I think on the top.
What are we doing on him next?
We originally set it for trial docket.
All right, it's set for trial, and you can sit down and drop in jail. That's the goal.
Or I'm Steinberger, you're Billy Martin, I want to fire you and see you.